Get ready, everybody, and rub your hands in glee because we're going to have a firefight presided over by Chief Judge Boasberg in the District of Columbia concerning the refusal of the Trump administration to stop flying planes to El Salvador after the judge ordered that they be grounded because he just got a basically big fat middle finger, go pound sand, F off declarations from Kristi Noem, Homeland Security Secretary, Todd Blanche, the number 2 in the Department of Justice, and a lawyer for the Homeland Security. What the issue is that Judge Boasberg has restarted his criminal contempt proceedings against the Trump administration, backed by the majority of the judges of the District of Columbia. There's only one judge on the District of Columbia, on the appellate court, who believes that Judge Boasberg should back off and not conduct his full inquiry about criminal proceedings against the Trump administration for violating his order to ground those planes and not send 200 men, all men, to El Salvador in the middle of the night, in violation of due process, in violation of the court's jurisdiction. That's a guy named Katsas, Judge Katsas, who was a Trump appointee. Everybody else said, Judge, you do you. You think that your order grounding those planes was violated willfully, contumaciously, in contempt of court? You do you. And so Judge Boasberg picked up the reins, pulled everybody back together again. The American Civil Liberties Union on one side, the Trump administration on the other, and said, we're gonna restart these proceedings. Firstly, I want to get to the bottom of who made the decision to continue to fly those planes after there was notice of my order. And you can see already, and I will map it out for you in these 3 one-page, 2-paragraph declarations, sworn statements under oath that the judge allowed in first instance for the Trump administration to submit. I will show you where they are lying about the timeline and about the orders of the court and the timing of the order to send the planes or not turn them around. Now, all this is going to lead to is the judge calling all of these people into court under oath to be cross-examined and grilled by the judge. He let them do their declarations first, and they decided to give him the big FU sign, which is no surprise because Emil Bovee, who's now on the Third Circuit Court of Appeals, but was the number 3 lawyer in the Department of Justice, was the one that was involved in all of this. His declaration is missing, was not submitted. I'm sure they're going to argue they had no control over a Third Circuit Court of Appeals judge now, that he's been elevated by Donald Trump. And Emil Bovee is at the heart of another scandal that the judge believes is relevant to his inquiry on criminal contempt. And that is the scandal involving what Emil Bovee told the immigration litigation unit of the Department of Justice, headed by a guy named Drew Ensign, and at the time, a guy named Erez Ruveni. Erez Ruveni got fired for telling the truth to federal judges about the illegality of sending these people away from federal jurisdiction. He then submitted a 38-page, single-spaced whistleblower complaint against Emil Bovee when he was up for confirmation at the Senate for his Third Circuit Court of Appeals position. And what the bombshell that Judge Boasberg wants to get to the bottom of is Erez Ruveni's statement under oath that he was told by Emil Bovee to go tell federal judges to go F off and to continue to deport people, remove them under the Alien Enemies Act. That is not answered in any of these declarations now filed by the Trump administration and its Department of Justice. I'm Michael Popak. You're here on Legal AF. Hit the subscribe button. Check to see if you are subscribed. It's all for free. We have no paywall, but we are trying to get to 1 million subscribers to get us ready for 2026 and that all important time in our national history. All right. So the judge said out loud about 2 weeks ago, I want to hear from Erez Ruveni, the former lawyer for the Department of Justice, about what he was told by Emil Bovey. Emil Bovey missing from the declarations, but not going to be missing from the courtroom. And we're going to watch a battle where Judge Boasberg, who's constantly attacked by the Trump administration, is going to try to pull in through his own subpoena and his own order Emil Bovey. He has the power to do that. He is a fact witness. And there'll be a whole battle about that because the judge said, I read what was in Erez Ruveni's declaration, his whistleblower complaint, which now explains why the planes continue to fly to El Salvador despite me ordering them grounded. Erez Ruveni, by the way, is now a lawyer for Democracy Forward and works with Skye Perryman and her team on the hundreds of cases against the Trump administration. I'd love to get Erez Ruveni on to talk about some of these issues when the time is right. Now, here's what the order was, which we'll post on Legal AF Substack for our paid members on Legal AF Substack. Here's what the original order was issued on the 28th of November, and then I'll read you the declarations that have now been filed. It says, the government now for the first time has identified who purportedly made the decision not to recall planes containing Alien Enemies Act detainees on March 15th, Homeland Security Secretary Kristi Noem. Defendants nonetheless maintain, relying heavily on Judge Katz's concurring opinion for the D.C. Circuit Panel, that her decision was proper and not contumacious, not as an act of contempt. As a result, the government posits that no further steps are warranted because the defendants didn't violate this court's order. But the judge says, given that the other two panel members, plus the majority of the en banc court, meaning all of the other judges of the district circuit court, did not agree with Judge Katz's, the court is not prepared at this juncture to terminate its inquiry. Instead, it must determine whether Secretary Noem or anyone else should be referred for potential contempt prosecution. In other words, the court must decide if the court order was clear and reasonably specific, the defendant violated the order, and the violation was willful. If all that happened, somebody's going to jail. In conducting the inquiry, the court has now ordered that by December 5, the government shall submit declarations from all individuals involved in the decision not to halt the transfer of class members on March 15th and 16th, and they shall detail their roles in such decision. Again, they did not submit one from Emil Bovey. They're probably arguing he's no longer in the government, so they had no control of him. Let me tell you where they lied. The first lie comes from Kristi Noem. No surprise. Declaration of Secretary Noem. 2 paragraphs. As Secretary of Homeland Security, I made the decision to continue the transfer of custody of the Alien Enemy Act's detainees who were removed before this court issued its temporary restraining order in the evening of March 15, 2025. Stop right there. The judge issued an oral temporary restraining order in the afternoon of March 15, 2025, which he later memorialized in the evening in a written order. But at the time he gave the oral order and the instructions to Drew Ensign, the lawyer for the Department of Justice, they were bound by that temporary restraining order, oral or otherwise. Here you see they're making another straw man argument. We don't have to comply with the oral pronouncement in the afternoon of the 15th. We just had to wait to see what would happen in the evening of the 15th while we continue to ferry people illegally in the middle of the night, kidnap them, and send them to El Salvador. Footnote to this entire discussion, those men are no longer in El Salvador. They were traded with Venezuela, which I thought we were at war with. If these are enemy combatants, we just sent them back to Venezuela. And so they're not even in El Salvador, again, getting them away from federal jurisdiction. Before making this decision, Kristi Noem continues, I received privileged legal advice. In other words, Judge, go F off. We're not telling you what the legal advice was. From Acting General Counsel of the Department of Homeland Security, Joe Mazzara, and through him from the senior leadership of the Department of Justice. under penalty of perjury, Kristi Noem. Okay, let's go to Todd Blanche. He's the number 2 in the Department of Justice. Side note, if Pam Bondi ever gets fired, it's going to be Todd Blanche as our Attorney General. That's my prediction. Todd Blanche, I am the Deputy Attorney General of the U.S. In the evening of March 15th, all right, already the evening of March 15th. So we're going to ignore the afternoon oral. We're going to wait till the evening of March 15th. After analyzing this court's oral statements at the TRO hearing. See, he didn't read them until the evening, despite the judge informing Drew Ensign that he had an obligation to tell his client at that moment to ground the planes. They waited around to read about it or hear about it in the evening. How convenient. And subsequent written order, then Principal Associate Deputy Attorney General Emil Bovee, now U.S. Third Circuit Court of Appeals judge, and I provided privileged legal advice to the Secretary of Homeland Security regarding the decision to transfer detainees who had been removed from the United States before this court issued those pronouncements. Wow. There's so much there to unpack, so much lying going on in this declaration. Those pronouncements included an earlier argument. It is clear from the timeline established by the judge in his creation of the record that there were some planes that were sent off but had not left airspace for the United States and could have been turned around and should have been turned around, and others that had left and had already left federal jurisdiction before the oral order was given. Others that took off between the oral and the written order was issued later in the evening. So there was a gap. And they just lied over all of that in their declarations. And they say, hey, they're all smushed together, oral, written, timing. I didn't get around to reading it until the evening. Maybe some planes had left. Maybe some planes hadn't left. Are you kidding me? And then Joe Mazzara, who is the Attorney General or the Acting General Counsel for Homeland Security, he says the same thing. He says, I gave advice to Kristi Noem about the legality of continuing to transfer under the Alien Enemies Act. DHS had removed these terrorists from the United States before this court issued any order or oral statement. They're not even saying the oral order is an order. It's just a statement regarding their removal. So they're not even consistent as between the 3 declarations about what the F happened. All this is going to lead to is Boasberg calling everybody in, including Emil Bovee, to testify about whether there's been contempt here. Let me show you 2 quick clips to end this hot take. One is Erez Ruveni in giving his statements to 60 Minutes in an interview. Remember, now he's with Democracy Forward as a lawyer, about what he was told by Emil Bovee. And then I'll show you the clip back to back of Emil Bovee being grilled by Senator Adam Schiff about whether he ever gave the code red, whether he ever gave the F instruction to people like Erez Ruveni. Let's play it.
At the beginning of the second Trump administration, you were promoted again.
That's right. Very soon into the administration, I was selected to be the acting deputy director of the immigration section, overseeing about 100 attorneys and every case that arose in the federal district courts.
But it was the very day of that promotion, Friday, March 14th, that he and others were called to a fateful meeting with Emil Bovee, President Trump's newly appointed number 3 at the Justice Department, who was once Trump's criminal defense attorney.
And we were told at this meeting that over the weekend, the President of the United States would be signing a proclamation invoking something called the Alien Enemies Act. This is a wartime law from 1798, invoked 3 times in the nation's history during the War of 1812, World War I, and World War II.
The Alien Enemies Act allows rapid expulsion from the U.S. of the citizens of enemy nations during a war. But without a declared war, Trump used it against more than 100 Venezuelans that the government said were terrorists. They were to be denied their right to be heard by a judge. Ruveni says Bovee expected a challenge.
Bovee emphasized those planes need to take off no matter what. And then after a pause, he also told all in attendance, and if some court should issue an order preventing that, we may have to consider telling that court, you.
And when you heard that, you thought what?
Felt like a bomb had gone off. Here is the number 3 official using expletives to tell career attorneys that we may just have to consider disregarding federal court orders.
Let me ask you, since you are under oath, in the complaint it says, Bovee stated that DOJ would need to consider telling the courts "F you" and ignoring any such court order. Did you say anything of that kind in the meeting?
Senator, I have no recollection of saying anything of that kind. To the extent I
Wouldn't you recall, Mr. Bovee, if you said or suggested during a meeting with Justice Department lawyers that maybe they should consider telling the court "F you"? It seems to me that would be something you'd remember, unless that's the kind of thing you say frequently.
Well, I've certainly said things encouraging litigators at the department to fight hard for valid positions that we have to take in defense of our clients.
And have you frequently suggested that they say "F you" and ignore court orders? Is that also something you frequently do, such you might not remember doing it on this occasion?
No, and as I explained, I have never directed.
So did you or did you not make those comments during that meeting?
Which comments, Senator?
You really need me to repeat it? Did you suggest, as Mr. Ruveni wrote, that DOJ would need to consider telling the courts "F you" and ignore any such court order?
I did not suggest that there would be any need to consider ignoring court orders. At the point of that meeting, there were no court orders to discuss.
Well, did you suggest telling the courts "F you" in any manner?
I don't recall.
You just don't remember that.
Welcome back. I'm glad you're here. Hit the free subscribe button. This is the kind of content you need, that you deserve. We curate it for you here on Legal AF. Come over to Legal AF Substack as well. After you became a member here for free, come over to Legal AF Substack. And if you can swing becoming a paid member for less than $7 a month, then you get access to all sorts of we unlock a treasure trove of other information, including all of the filings. You'll be able to read them for yourself, including all of these orders and these declarations that I just talked about. So until my next report, I'm Michael Popak. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.